watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman. I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. Today's show is part 2 of a series focusing on Social Security law. With us now, again, to further explore this topic is attorney Chris Cornaghie. Chris, thanks for being with us again.
And my pleasure.
In part 1 of the series on the Social Security law, we talked about Social Security in general and what benefits there are and the different portions of the pie and how they can be distributed to other family members. And we briefly touched on, I guess, SSI, which is the disability component. And I think for part 2, we're focused more on the disability component, but for those who may have missed part 1, you know, which they can find it out there on the web still if they want to see it, I guess we need to briefly do a recap.
Right. In part 1, we had an overview of a lot of the benefits involved in Social Security, the various provisions, including Medicare, et cetera. Now, this part, we're going to talk more specifically about the disability benefits available under 2 sections of the Social Security Act. As in the discussion last month, we talked about disability benefits under Title II, and that's again a Roman numeral II. Those benefits require that the wage earner, that's the Social Security number holder, have paid in sufficiently into Social Security. They have to work at least 10 years during their lifetime, again not necessarily consecutively, but at least as an aggregate. And for disability purposes now, purposes of today's discussion, they have to have worked at least 5 out of the last 10 years from the date that they claim to be disabled. The other type of benefit was supplemental security income, which is also a disability program but has a fairly significant income and resource limitation. So these 2 programs together, they're both Social Security and they're both disability. They just happen to have different financial requirements. To relate again, the insured status requirement, which is extremely important in a Social Security disability case, Social Security uses what are called quarters of coverage. And a quarter of coverage is, in effect, a quarter of a year: January, February, March, April, May, June, July, August, September, October, November, December, in which an individual would have worked and paid enough into the Social Security Fund. So when they talk about time periods and the insured status requirements, Social Security uses the quarter of coverage standard. So it's 20 quarters out of the last 40 quarters. Now that equivalates, of course, to 5 out of the last 10 years, but that's Social Security's terminology. That time period, when a person meets that 20 out of 40 requirement, is called the date last insured, DLI for Social Security purposes. So they must prove that they're disabled on or before the date last insured. Social Security uses, for disability purposes, what is called the sequential evaluation of disability. Sequential, meaning one after another. There are a number of steps. For the person to be found disabled and eligible for benefits, they have to get through all of the steps. Some of them, or most of them, is not sufficient. Social Security and Congress have defined disability as an individual shall be determined to be under a disability only if his or her physical or mental impairment or impairments are of such severity that they are not only unable to do their previous work, but cannot, considering their age, education, and work experience, engage in any other kind of substantial, gainful work which exists in the national economy. Now, there are an awful lot of legal provisions contained in that very small paragraph, and that's what the sequential evaluation of disability is designed to accomplish. Step number 1, is the person working? So first, the person has to disclose and show, by virtue of their work activity, that number 1, they've worked enough during their lifetime and the recent time period to qualify for disability benefits, but you cannot be working, as that term is defined by Social Security, and be disabled simultaneously. If you're working substantially, then irregardless of what your medical condition might be, you're not disabled because you're working. Social Security defines that as both substantial and gainful. Substantial means time. How much time are you spending doing this? Gainful, is it any kind of monetary value? As a general rule, if an individual is working and making roughly over $1,000 a month consistently, they're not eligible, period. It doesn't matter what their medical condition might be. Many people might receive a notice from Social Security after filing for disability benefits that they're not disabled, but in reality, what Social Security is saying, you're working, which is why you're not disabled. If you make less than about $250 a month, then Social Security will generally waive that off. But anywhere in between, someone working on a fairly regular basis, and by that I mean more than maybe say 3 months, that's going to be an issue. Gainful, that's gainful. Substantial means amount of time. Probably if you're working 20 hours a week, 24 hours a week, certainly 30, 32 hours a week, that's getting into full-time work. So whether you're making over $1,000 a month, now you might be denied because you're engaging in substantial work. If you're working, say, 8 hours a week, or 4 hours a week, or 6 hours a week, Social Security will probably discount that as not substantial. That's step one.
Okay.
Step two, you have to have a severe impairment, meaning it has to be something that's obviously of significant restriction, and part of that requirement is that the impairment has to have lasted for 12 consecutive months. This is another step where people may have filed for Social Security disability benefits. They receive a notice from Social Security that says you're not disabled. They've only been off work for 6 months. Consequently, it hasn't met the 12-month rule yet. There's a second part to that phrase. You have to be disabled for 12 consecutive months or be expected to be disabled for 12 consecutive months. In many instances, Social Security doesn't utilize that second clause. They look at the first one, has the person been off work, etc. So as an example, let's say a person may be a carpenter and perhaps they broke their arm or their leg and they're definitely laid up and they're unable to do any kind of work. Makes sense. Are they going to be disabled though for 12 consecutive months, or is their condition going to improve, recover, they can go back to work? If so, they're not eligible for benefits under Social Security disability. Interestingly enough, there's some other provisions that talk about the work activity.
And we've got to take a break, but we'll come back. We'll talk more about those provisions that deal with the work activity, and we'll continue our discussion on Social Security law. Please stay with us.
They'll test you, try to break your will. But however loud the loudness gets, however many cheese puffs may fly, you're the driver, the one in control. Stand firm. Just wait. And move only when you hear the click that says they're buckled in for the drive. Never give up till they buckle up.
Cinderella found the pet that fits her perfectly. Tiana gave her pet the royal treatment. Belle found beauty where no one else did. And you can too. Share your heart. Share your love. Bring home your forever friend. Make a shelter pet part of your world. Happily Ever After begins at theshelterpetproject.org.
You You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show is attorney Chris Cornaghie. We are discussing Social Security law. Chris, before the break, we were talking about the different steps in the, I guess, as Social Security looks at as to whether or not you qualify for disability. And we had made it through step 1, and we were in step 2, which has to do with whether or not there's a significant impairment.
Correct. And let me back up for just a minute. If another agency, even another federal agency, say the Veterans Administration, or other state agencies, or even private insurance companies, make any kind of statement that an individual is disabled, that's not binding on Social Security. They make their own decisions based upon the evidence, et cetera. Now, they may consider that, but it's not absolute. Going back to the severe impairments and the work activity, if you've worked less than 3 months, even if you've worked it over the limit I described, Social Security may be willing to agree that that's an unsuccessful work attempt, and that wouldn't count. When I talked about substantial and gainful activity, I meant fairly consistent work activity as well. Also, if a person is working, and let's say they do have a fairly significant medical problem that requires them to pay out-of-pocket expenses that allows them to continue to work, those expenses can be deducted from their earnings, so that therefore they would then be under the particular threshold. One other interesting aspect of the Social Security law is that illegal activity is not necessarily a bar to the work provisions. If you happen to be making substantial and gainful money through illegal activities, you're still not disabled. The severe impairment means that you have to have the restriction in basic activities, and those are the ability to do physical functions such as walking, standing, sitting, etc., possibly seeing, hearing, speaking, basic mental capabilities. So when we're talking about having a severe impairment, it has to be something that affects those basic type of capabilities. An individual that's got some particular type of impairment and they've gotten through the first 2 steps, then they arrive at the 3rd step, which is Social Security has a complete, very extensive set of medical findings, lab results, test results, et cetera, pertaining to just about any type of medical condition that you can imagine, such that if an individual does have impairments, medical impairments, and that the documentation substantiates the medical impairments at a level as indicated in those listings, Social Security will determine that the individual is disabled at that point without any further consideration whatsoever. And rightly so, because those standards are extremely severe, and if an individual has impairments that meet those, there's absolutely no doubt that they're indeed disabled. So that's sort of a separate step. If that's not applicable, then you go on to step 4, which is, can the individual return to any work that they've done in the previous 15 years? And that is any kind of job that they held for generally longer than about 3 months. Now, when Social Security talks about returning to past work, they not only mean work as you did it, but in effect, work as it might be done in the national economy. As an example, let's take the position of the industrial sewing machine operator. In various companies and businesses, an industrial sewing machine operator might lift big bundles of material. They may go from one workstation to another, either getting material or with finished product. So consequently, their work may entail standing, walking, stooping, bending, squatting, lifting 20 pounds, 50 pounds, it's hard to say. Well, there are other industrial sewing machine operators where perhaps the individual is seated throughout the entire workday. They really don't lift anything of any weight whatsoever. Perhaps they're sewing on buttons or doing buttonholes. They don't move from workstation to workstation, so that would be a much lighter type of work. An individual who did the first type of work might say, I have a medical problem that keeps me from doing this type of work. I can't do it any longer. I must be disabled. Not necessarily. You might be able to do that same job as it is somewhere else. Furthermore, Social Security is a federal, national program. So work circumstances here in the Mid-South, availability of jobs, types of jobs, are not necessarily determinative. People could be employed in California or Texas or Florida, and Social Security will say that. We think that you can do some other kind of job. It may not necessarily be where you live. The inability to drive to and from work is not necessarily a disability in and of itself. You might be required to take the bus or take the subway. The person might say, there's not anywhere I live. Move to Chicago. There is there, or Los Angeles, or Boston, or whatever. So when they talk about being unable to do your past work, it entails all of those other factors. Furthermore, it can be, as I said, any job that you may have held in the last 15 years. Let's say the person was a truck driver for, say, 12 years or so, had a commercial driver's license, and then as a result of either high blood pressure or diabetes or something else, perhaps they can't qualify for the commercial driver's license anymore. They can't drive a truck. But for 2 or 3 years, maybe they were a dispatcher. They were sitting in the office, they were dispatching trucks and vehicles, etc. Social Security most likely will go back to that job no matter when it was, even if it was 10 or 12 years ago, and indicate that the person could do that line of work. And that is indeed the line of work that then the individual must show that they cannot do. Finally, if you get past all the steps I've named up to this point, then you get to the last step in a disability evaluation, which is naturally the hardest. And that is, you now have to show that in effect, given your age, education, and work experience, you can't do any kind of work that exists anywhere in the national economy on a regular, sustained basis. Luckily, Social Security is not allowed to point to jobs that are part-time or seasonal or temporary. They have to be able to say that the individual can work on a regular 8-hour-a-day, 5-day-a-week, day after day, week after week type job without undue absences or restrictions. Believe it or not, the Social Security Act is weighted in favor of people who are 55 and older, and it is weighted against people who are 50 and younger. Okay. Age is a definite factor.
And when we return, we're going to discuss the age as the factor there. We'll talk more with Chris about Social Security law. Please stay with us.
Body language can tell you all sorts of things. Like someone is having a stroke. Know the sudden signs. Learn fast. Face drooping, arm weakness, speech difficulty. Time to call 911 and get them to a hospital immediately. Learn the body language and spot a stroke fast.
Preventing wildfires. That's all Smokey wants for his 70th birthday.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is Chris Cornaghie. We're talking about Social Security law. I think we had just gotten through the majority of the steps, and we're on the last step of qualifying for disability. And you were beginning to talk about how they look at someone that's under 55 with more scrutiny than someone that's over 55.
Well, we were talking about the age categories with Social Security because, as an example, if you had an individual who was 47 years old and had multiple back injuries and had a particular type of work, they might not qualify for disability benefits, and yet someone who was 57 years old with exactly the other same set of factors would qualify for benefits. And so part of this last step involves actually the use of a matrix, which is in effect the plugging in of various factors, age being one, education being one, past work experience being one, and the level of work that Social Security concludes a person can do, and in effect then it will simply read out disabled or not disabled. So the first factor is age. The older a person being a more positive factor for disability, younger individuals, that's a negative factor for disability. If you're under 50, Social Security considers you to be a younger person. If you're 50 to 54, you're closely approaching advanced age. If you're 55 to 59, you're advanced age by their standards. And if you're 60 to 64, you're closely approaching retirement age. So that's the first factor, is to determine where the individual falls within the age categories. Second factor, what kind of work have they done? Social Security categorizes these as heavy work, medium work, light work, and sedentary work. Medium work, lifting just about 50 pounds on a fairly regular basis, 25 frequently, standing and walking most of the time, engaging in activities such as stooping, bending, squatting, climbing ladders, climbing stairs, etc. That's medium work. Light work, lifting between 10 and 20 pounds. It also might have the component of a lot of standing and walking. Could be seated though. Could be an industrial job where you're seated on a bench type process. And does require some standing and walking, but not necessarily all day long. Sedentary work, lifting no more than 10 pounds, files, folders, small tools, etc. You're seated most of the day. There may be some component of standing and walking, not necessarily all at one time. And that's what sedentary work would entail. So the person's work, again for the past 15 years, has to be categorized in those various type of physical requirements. And then finally, there's the skill level. So there's unskilled work, semi-skilled work, and skilled work. Unskilled work can generally be as a job that can be learned fairly effectively, doesn't require a dramatic amount of education, not a lot of training. And then skilled and semi-skilled work, etc. The law is weighted in favor of people who have done unskilled work, and have weighted against people who have done semi-skilled or skilled work under the theory they're more likely to be able to transfer skills into some other type of work activity. Education. Social Security is weighted against people who have a good education, and Social Security considers a high school education to be a good education. So if an individual has more than a high school education, their ability to obtain disability benefits will be somewhat reduced based upon their education alone. People with marginal educations, that's a 6th grade or less, they have a higher probability of obtaining disability benefits, again under the theory if they suffer a significant medical problem, may not likely be able to retool into some other kind of industry. So all of these items fit together in the big matrix, and it becomes then the attorney's requirement and job to determine where their client's circumstances fall. As an example, let's say a person became disabled and they were 49. Well, that is obviously a detriment. So you might wait and claim disability until you turn 50, when actually these factors somewhat change. The RFC, that's what's called the residual functional capacity, and that's what people will see when they see the denial notices sent out by Social Security. It will say, we understand that you're not able to do your past work, but we think you can do some other kind of work. And again, when Social Security talks about work, and individuals, of course, talk about work, it's definitely not the same thing. As an example, Social Security would consider jobs such as parking lot attendant. That's a person who sits or stands in glass booths. They don't lift anything heavier than, say, a dollar bill, make change, let the car go out. Telemarketer, sit at a desk, or you could stand if you wanted to, have a set of earphones on, call people on the phone, ask them to buy various things, etc. Security monitor. Now that's not a security guard, but a security monitor is someone who might sit at a desk and look at a big bank of TV screens, and all they have to do is report on various vehicles coming in and out of some place. When Social Security talks about being able to work, those are some of the jobs they mean that a person could do. So it's not necessarily, say, a person thinking, well, this is the kind of work I used to do, I can't do that anymore, obviously I must be disabled. Not necessarily so. There are some different rules for special circumstances. Individuals who are blind do have some different disability rules than what I've already gone over. And again, the way to file for Social Security, of course, is to either go online at ssa.gov. A person can fill out the application themselves. It can be rather tedious, but it can be done. And you can file all the appeals online. Again, the deadline for filing any appeal in a disability matter from any determination by Social Security is 60 days, and that is 60 calendar days, including weekends and holidays.
Yeah, we've got a little bit less than a minute, but the thing that I always try to stress to viewers is every practice area is complicated, and with Social Security, it's one of those that even if you're looking at whether you're going to take early retirement or your full retirement benefits, spousal rights, these sorts of things, doesn't hurt to call up an attorney that practices in that area and talk to them, because I know you've had some attorneys that have retired who have called you and said...
It would be very prudent to avail yourself of that. I have had some individuals call me who are extremely knowledgeable, well-educated, and yet can make some of the simplest mistakes unbelievable.
And I thank you for being with us.
It's been my pleasure.
Yeah. Our time is up for this edition of Law Talk. I would like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you would like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more legal topics. Until then, I am Vince Perryman, and thank you for watching.